Our next speaker, for those of us who do a lot of trial work and are in court a lot, he's somebody we see on a frequent basis, sometimes daily, sometimes weekly basis. He is an undergraduate from Florida State. He has a law degree with honors from the University of Miami. Prior to taking the bench, he was an assistant public defender. He was also an associate with Simon Schindler and Sandberg. He then went on to be a solo practitioner and took the bench in 1998. I previously served in the criminal and juvenile divisions and is now on the civil division. Last personal story today, I've been in front of him both as a defense lawyer, defending hospitals and doctors, and plaintiff's lawyer, representing plaintiffs. And there is this legend out there that judges are sometimes biased, lean one way or the other. And when you're dealing with Judge Echarte, that is simply a myth. He is fair to plaintiffs, he is fair to defendants, he treats the people that come in pro se for foreclosure the same, and he treats any of the lawyers on this panel. I've also had the pleasure of trying a case with Stuart in front of him with a catastrophically injured child back in 2009, I believe. And I can tell you that he was fair. The jurors loved him and respected him. The case resolved after a few days, but every one of the jurors that we talked to after said with great respect they had for Judge Echarte, not only because of the way he handled them as jurors and the way he handled us as lawyers, but because he bought them Cuban coffee every afternoon. So without further ado, I present to you Judge Pedro Echarte.
That was a very nice introduction, thank you. When Stuart called me to find out if I would participate in this seminar, and I agreed to do it, a few days later he sent me the tentative schedule, and he scheduled me for an hour. So I called him and I said, listen, I got like 5 minutes worth of material, an hour isn't going to work, please don't do that to me. He said, don't worry about it, I'll take care of it. I get the updated schedule, and I'm set for half an hour. Well, I still have 5 minutes of material, and so you can ask me questions for about 25. I actually changed my presentation this morning because when I was driving to court, John Seligman called me, and he said, you got to tell him the truth. Tell him the truth. So I'm going to tell you the truth about my view from the bench. Every day I take the bench, I gaze out into my courtroom, and what I see is an antiquated, tiny, grungy little courtroom that may or may not be infested with mold. What I hear every day, no matter which way I'm ruling, is a lot of wailing and gnashing of teeth. This morning, in fact, during one of my foreclosure calendars, at the end I actually heard weeping. And I looked up and looked around to see who was weeping and realized it was me. So, seriously. Stuart suggested that I talk to you guys about do's and don'ts, about practicing in my division and in circuit court generally, and I intend to do that. But before I get to that, I want to talk a little bit about Tallahassee. As Scott mentioned, I went to Florida State University, and the word Tallahassee used to bring very fond memories. Now when I think of Tallahassee, I get the heebie-jeebies. And I don't know if you folks are following what's going on in Tallahassee. If you're not, you need to, because we need to do something about that. Let me see if this works. Perfect. This is Jim Moran's cartoon from yesterday's Herald. Did anybody see that yesterday in the Herald? Raise your hands if you saw it. Okay. This is what I want to start out talking about. Do any of you think that the community understands the importance of the independence of the judiciary?
No.
I agree with you, and I think that a lot of lawyers don't actually understand the full significance of what that means and the danger that we're in because of this kind of stuff. I think our founding fathers considered the independence of the judiciary to be one of the paramount governmental interests. I don't think that it's lost any importance over time. I think it's as important today as it was then. In fact, the first sentence of the preamble of Florida's Code of Judicial Conduct reads as follows. Our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us. The first sentence of Canon 1 of the Code of Judicial Conduct states, an independent and honorable judiciary is indispensable to justice in our society. I'm going to take that one step further and suggest that it's indispensable to our constitutional democracy. I think everyone in this room understands how important it is, and I think everybody in this room understands that we need to protect it at this time. I'd like to take a moment to consider some of the things that the executive and legislative branches of government have been proposing in Tallahassee. The governor wants to eliminate judicial nominating commissions for appellate judges and Supreme Court justices. With respect to judicial nominating commissions for trial court judges, he wants to change it so that he appoints all the members of the commission with no input from the bar. The legislature wants to split the Supreme Court into a civil and criminal division, which would add 3 more justices, which would be appointed by the governor, who doesn't want a judicial nominating commission. The justices would have no say in which division they serve in. The Senate wants Senate confirmation of Supreme Court justices. They're proposing legislative oversight of the Supreme Court's rulemaking authority. On merit retention of appellate judges and Supreme Court justices, the legislature has proposed a 60% voter approval in order for the judge to keep his or her seat. Clearly, this would lead to many judges not being retained, and again, more appointments for the governor. They want to reduce pay and benefits for all judges and court personnel. This would be the second reduction for judges in the last 2 years. This would result in more judges leaving the bench, and in turn, more appointments for the governor. This one's a good one. A judicial incentive program to encourage judges to move cases faster. I can move cases really fast, but you won't get to talk. And they're proposing further reductions in the state court's budget, obviously imperiling our ability to function at all. When one party has a supermajority in the legislature, and that same party occupies the governor's mansion, no matter which party it is, I'm telling you, we're headed for trouble. The last thing we need, and what we should not tolerate, is a politicized judiciary. Our legislative and executive branches are acting in a manner demonstrably at odds with our founding fathers' blueprint for an independent judiciary. If sacrifices to the independence of the judiciary are permitted today, precedent is established for the constitutional transgressions of tomorrow. I think we need to do more than what we're doing. Judges are not in a good position to do much about this. Our ability to speak is curtailed, and I think that it's up to the lawyers to take care of our Constitution and our society. In the case of Peterson versus Stafford, the Minnesota Supreme Court stated, the methods by which the federal system and other states initially select and then elect or retain judges are varied. Yet the explicit or implicit goal of the constitutional provisions and enabling legislation is the same: to create and maintain an independent judiciary as free from political, economic, and social pressure as possible, so judges can decide cases without those influences. When you think about what's happening in Tallahassee, clearly the goal does not seem to be to create and maintain an independent judiciary. And unfortunately, the alternative to an independent judiciary is universal distrust and distress. Now, for those of you that think that I sound a little bit like Chicken Little proclaiming the sky is falling, there's a huge difference between me and Chicken Little. Chicken Little was wrong. Stuart suggested that I discuss with you do's and don'ts about practicing in my religion. Stuart suggested that I discuss do's and don'ts about practicing in my division. Most of this relates to things that you submit ex parte. And the first thing I want to talk about is ex parte defaults. Let me put this all in perspective. I have in my division 5,300 or so cases, which is a lot of cases. When I came into the division 5 years ago, I had 1,750. It's quadrupled. When you submit things to judges, you need to make sure that your submissions are complete. When you submit an ex parte default, it's not just a cover letter and an order of default. You need to submit proof of service, non-military affidavit, a correct order, a motion, anything that I need to look at, you need to send to me. Because if you just send me your order with a cover letter, and if you think I'm going to go down to the clerk's office, pull the file, confirm that there's service, it's not going to happen. And it causes you guys to do twice as much work, and it causes me to do twice as much work. Because when I get the incomplete package, all I do is give it back to my JA, who sends it back to you. And then we all start over again. But it wastes a lot of my time. With 5,300 cases, I get a lot of ex parte stuff that's just not complete. And please consider, I'm begging you guys to, and I'm not saying it's you guys, but I'm begging the lawyers to be mindful of what we go through when we review mail every day, and no joke, it's this much every single day. Same with default final judgments. You need to submit proof of your default, your motion, supporting affidavits, and correct orders. I say correct orders because oftentimes I get orders on lawyers' stationery. I don't enter orders on lawyers' stationery. I don't think everybody else does. Why lawyers submit orders on their stationery is a mystery to me. How many of you know that a motion for continuance, absent good cause, must be signed by the party? Anybody know that? Do you guys do that? Not in my division. Nobody does that in my division. So we waste a lot of time. I take the bench, I call the case, the lawyer's there with their motion for continuance, and I just strike it. And the lawyer has to start over, and I have to reconsider it down the road. Get it signed. Discovery disputes. You must make a good faith effort to resolve it. You must certify in either your motion or your notice that you have made a good faith effort to resolve it. And a good faith effort is not merely sending an email to your opponent saying, give me the discovery or else. Pick up the phone. Pick up the phone, call your opponent and see if you can work it out. I send lawyers out into the hallway all the time. 70% of the time they resolve it. And the only trial tip that I want to give you guys is you really want to rethink using videotape discovery depots at trial. If you watch the jurors' faces, and I've had lawyers ask for sidebars, Judge, the jurors are sleeping. And I think, you put them to sleep. You can't play these 5 hours discovery demos and expect to prove anything. They're not listening to you. I'm a firm believer that less is more, so I'm giving you less, hoping you'll think it's more.